Be members of the Windsor County DUI Treatment Court. And this is a new project for us, something that Ted's been working very closely with them on. Very pleased to have them here today. Tell us what their experiences have been, what we can use, what has worked, what hasn't worked, and thank you for being here.
Well, thank you. Is this too close? Is it too loud? A little bit? Is that better? Everyone hear me? Great, great. So first, let me just say thank you for inviting us here today. It is a real privilege to come and speak about the newest treatment court in Vermont, the Windsor County DUI treatment docket, and it is the only DUI treatment court in Vermont. As I said, it's new, and we feel very honored to be here today to talk to you. It is the end of the day, and it is very appropriate for us to be talking about this at the end of the day. I'm going to echo what Judge Grierson said. The DUI treatment docket really is at the end of the continuum, and we are the farthest end. We are not only post-plea, we are post-conviction. So these people have to actually be sentenced to come into our program. Our Deputy State's Attorney, Glenn Barnes, is our prosecutor on the team, and we have Mark Young, who's our supervising case manager. Attorney Barnes is going to be speaking about the population because, again, that's going to be very important. This is, again, the high-risk, high-need group. So these are not the low-risk offenders. So in a nutshell, I'm going to tell you first what the DUI treatment docket is. I'm going to tell you a little bit about how it operates, and then we're going to talk about who it's for. We're going to give you some of the numbers, some of the cost savings, and we're also going to talk about some of the treatment. So it's a lot to cover, very short period of time. I like to talk about what the DUI treatment docket is by starting about telling you what it's not, and telling you a little bit because it's starting with what you're already familiar with, which is a traditional court. So if you will, think about any kind of criminal hearing, okay? And you walk in the courtroom, and who do you have sitting there? Well, you've got the Deputy State's Attorney, so you've got your prosecutor. You also have your defense attorney, and of course you have your judge. And the attorneys are probably making arguments or presenting their case. If it's a motion hearing, the judge is making, rulings on objections. But who else is there? Well, you've got the person who's most intimately involved, and that's your defendant. And I want you to think about that person for a minute, because what is he or she doing? Well, hopefully sitting there looking attentive and being quiet, right? And I say it kind of tongue-in-cheek a little bit, but not really, because so you think about that person if you dial back to their initial appearance. So they've gone through some kind of circumstance, some factual circumstance that got them to court in the first place. So here they are. They come in for their initial appearance, and what do they want to do? Well, lots of defendants don't want to do anything. They want to get in and out. They don't want to say anything. But some of them, they're looking at this as their first opportunity to unload. They want to talk. They want to share their story. They might want to explain. And what do you say to them? So when I was in Ohio, I was a magistrate, and I did a lot of initial appearance hearings for the judges that I worked with. And I would go to the jail once a week, and they would come in, and invariably there'd be at least one that would start up, and I'd have to say, stop. Everything you say is being taken down. It can be used against you. And we know it's for their best interest. We're protecting their interest to tell them not to talk, but they're shut down. We're telling them, don't tell us what's going on, right? So then we go back to our hearing, and they're still sitting there, and they might testify. It's not that they don't speak at all. But really, if you fast forward to the very end, when they're finally given this opportunity to talk directly to the court, what's it usually at? Sentencing, right? So they go through this whole process designed to protect them, maybe don't get the opportunity to say the things that they really want to say, and at the end they get their punishment, and that's their whole interaction, right? So the treatment court is very different, all right? Let's take it out of the courtroom. So I have my little stones here. One, I like to hike, but the other reason is because it takes a team of people to make the treatment court work. So who's on our team? We have our team approach, where we're going to start with our same players that we had in the courtroom. So we've got our judge, and the judge is really, really important in this mix. Because if there's, it's a team model, it's a team consensus, but if there's ever any disagreement, the judge is still the judge. The judge is the ultimate authority and can make the final decision. So who else do we have on our team? Well, we've got our state's attorney, and we've got our same defense attorney, And then we bring all the other people in to sit on the team. So now we've got the case manager, Mr. Young, and we've got the treatment providers. We bring the clinician in. We've also got the probation officers who are going to be supervising these people. Again, high risk, high need. They need supervision. And then finally, we've got me. I'm the coordinator. So this is our program team. And what we do is we come out of the courtroom, we go in our meeting room, and we sit down. And before every treatment court, we have what we call a staffing. It's a special meeting. And what do we do in that meeting? Well, we sit down and we talk about every single person in the program. Okay? And what happens is these are evidence-based programs. We're not reinventing the wheel. We're not just sitting around to have coffee to talk about what they're doing. We use best practices. These best practices, we follow the 10 guiding principles of the DUI courts. Those come to us from the National Association of Drug Court Professionals and the National Center for DUI Courts. I do use DUI and DWI interchangeably, just to make that clear for this. These programs use intensive treatment. So it's evidence-based, and when I say intensive treatment, it's 18 to 24 months is our minimum time frame. These people have treatment meetings, case management meetings, they have community meetings, they get frequent and random drug testing and alcohol testing. So it's very, very rigorous, this program. We also have accountability, and that's really critical. Again, this is a post-conviction model. People have to plead to get into it. They also have to come to court and address the judge. So there's a lot that goes into this program. So let's go back to our meeting. So we sit down and we talk about every person. We talk about where they are in the program. It's phased. So at the beginning, they might have one set of requirements, and some of those requirements will change over time. So by the end, we've got people working, going to school. We've got people, getting active in their community again and trying to replace the behaviors from their life with the positive ones so they can be good citizens again back in their own community, okay? So we're doing all of this to change their behavior, right? That's what we want to do, is change their behavior. So how do we do it? So I'm not going to pick on Tom or somebody else. I'm going to make somebody up. So if we've got Johnny, okay? Mark comes in as the case manager to our meeting, and he's going to report on Johnny. And he says, well, he's gone to all of his meetings. He's doing great. Didn't miss any appointments. We're all very excited. So we're going to use incentives to encourage that behavior. And I use an ice cream cone on purpose. One, I love ice cream. But two, because it represents that what we do is non-traditional. So an incentive could be the judge giving an encouraging statement. It could be the judge saying, we are so proud of you, let's have a round of applause, okay? And that can be enough. But it could be a coupon for an ice cream cone or a coffee card. It could be a button or a coin that they carry in their pocket. So during the week when they're really having a bad moment, they can reach in their pocket and go, oh, that's right, I'm working a program. So it's those things that we want to do to encourage that good behavior. Now what if Mark also then says, well, you know what, but Johnny had a positive UA. Well, we want to discourage that, especially if Johnny's really further down through the program and we know that he's capable of being abstinent. So then what we're going to do is impose sanctions, and we'll do both. Every behavior gets a response. So if there's good behavior, it gets an incentive. If something bad has happened, it gets a sanction. And sanctions are also non-traditional. So it could be a stern reprimand, it could be community service, it can be work crew, and it can be jail. Okay? So it's a spectrum depending on what the behavior is, where the person is in the program, and what we can expect of them. Now sometimes, what if that positive UA was something where Johnny isn't far enough along yet and really can't be abstinent? Then we have a treatment response. So that might be increased treatment, it might be residential treatment. It depends on what's really needed at that point in time for each individual participant. So what do? We do our incentives and sanctions, we figure it out all in our team meeting, and then we go into court. And what happens in court is really pretty spectacular because everybody goes in, the team when we're done, and we sit down, and the attorneys sit down, and the judge comes in, and the participants go up to the podium, and they do the thing that they don't do in traditional court. They come in and talk directly to the judge. And the judge asks them how they're doing. The judge wants to know what they've been doing, and the judge will say to them, hey, we're proud of you. You did these things right. Hey, everybody clap for this person. And it's very powerful. Some of these people have never had anybody in a position of authority ever say something to them. that can make that difference, that's positive and encouraging. So for some of these people, it's a brand new experience, and it's really overwhelming. So if you get the opportunity to go sit and watch sometime, do it. Do it. I guarantee you, at least one person in there, if not more, will really move you. Okay? It's really a powerful thing. So we use our incentives, we use our sanctions. The participant has their dialogue with the judge will do the incentives and the sanctions, and that's really sort of how it works. It's a really quick nutshell. Why do we do it? Well, reduce recidivism. We've heard that already today. And I'll give you some numbers. There's 3 Georgia DUI courts. There's a study that showed graduates from there had a 63% lower recidivism rate than a contemporary comparison group in 3 Georgia courts at the same time. So that's a pretty impressive number. And I do have my references. That, of course, means we have safer roads. That's why we're here today, right? Safer roads. I think you all know this. 30% of the 2012 traffic fatalities in Vermont involved drivers with a BAC level of .08 or higher. Nationally, those drivers are 7 times more likely to have a prior conviction for DUI. When Attorney Barnes talks about our population, that's significant for us, because those are the people we're looking for. Also significant is the high alcohol, like the hardcore alcoholic is usually defined as someone with a BAC of .15 or higher. That group is 380 times more likely to be involved in a single vehicle fatal crash than a non-drinking driver. That number is staggering. So our population is one that is very small, but is very dangerous. And you all see it. There is a cost savings. I'm going to give you just a nutshell. Attorney Barnes has a whole bunch of numbers specific to Vermont. It's about $4,000 to $12,000 per participant that comes through the program. And in that way, it seems like it makes sense in so many ways. If we can help these people get them off the roads and save money, it's a pretty amazing tool. So I'm going to turn it over now to our Deputy State's Attorney. He's the prosecutor on our team, Attorney Barnes.
So the first thing that, is this working?
Mine?
Green light. There we go. All right. So the first thing that I've been tasked with today is to try and explain why a prosecutor might get behind a program like this. And to be quite honest, this particular prosecutor got involved with this program because about 1.5 years ago, I applied for a job with Bobby Sand at the Windsor County State's Attorney's Office. He's now, you might know him as the DUI Court and Drug Court czar for Vermont. And he hired me, and he's like, oh, by the way, we're going to be starting this new DUI court. You're going to be my DUI prosecutor. Have fun. That's how I got involved. But then I started thinking, well, why are we doing this? And is this something I really want to get behind? Because, I haven't really seen anything like this before. And, I thought the job of a prosecutor was basically you take a police officer's case, you get your conviction, you try and impose some of the strictest sentences that you can, and then you can move on to the next case. And the main reason why a prosecutor should be interested in a program like this is that reduced risk of recidivism. I believe TJ earlier referred to the fact that it's something around a 42-43% recidivism rate in the state of Vermont. Currently, we treat a lot of these DUI participants who are DUI 2s, DUI 3s with programs like ISAP. Statistically, ISAP for non-completers are they have a 46% recidivism rate. For people that actually complete ISAP, that's 31%. So to put it in per person numbers, you're talking about 1 in 2 chance that they're going to reoffend. If they get treatment, it's 1 in 3. These DUI courts are actually, which have been peer reviewed, we're looking at 1 in 5, 1 in 6, 1 in 7. The Georgia court that Stephanie has already referred to, that was actually 1 in 8. So what we're talking about is significantly reducing the number of impaired drivers on the roads, particularly in this high-risk category. Who's it for? As Stephanie has already alluded to, we're targeting that high-risk population. And so from a legal standpoint, we're talking about people who have a third offense DUI or higher, so DUI 3, DUI 4. DUI 2 with a BAC of .15 or higher. A DUI 2 with a prior DUI reduced down. So that's for all you law enforcement officers and attorneys here, there's A lot of first-time DUI offenders, or maybe not a lot, but a good number, will find that their cases are eventually settled for something like gross negligent operation. And so it's not technically a DUI, but we know that it started as a DUI offense. We know that it's a drinking and driving related offense. So if they have one of those plus 2 DUIs, we're looking at them for this particular court. They also have to be appropriate for supervision. After they plead guilty, there's a 30-day, what we call orientation period, before they're sentenced. During this orientation period, probation and parole will approve their residence and make sure that they're someone that they can keep an eye on in a safe and responsible manner. And nonviolence. If they've got just a litany of assault charges and things of that nature, they're going to be excluded from our population. Also not included on this is we're not going to be taking DUIs where there was a serious bodily injury or death resulting. Those people are not eligible for our particular program. So this is just to give an idea for the state of Vermont. These are 2012 statistics. They were taken right from the Vermont Department of Public Safety's website. 378 DUI 2s, 173 DUI 3s. So this is actually a fairly significant population that we're talking about. The average sentence for someone serving a motor vehicle offense in the state of Vermont in a prison is 86 to 321 days. It's a fairly significant amount of time, and the reason why we brought that up is we're going to be talking about costs in a second here. So as many of you are probably aware, it's about $58,000 to house a prisoner in the state of Vermont right now. For when we ship them out to Kentucky, we're looking at about $26,000. As Stephanie had already alluded to, with these DUI treatment dockets, we're talking in between $4,000 and $12,000 per participant. So if you look at each possible participant, we're looking at some numbers where we can be saving literally millions of dollars by going through a treatment-based model instead of an incarcerative model. And not only is it cheaper, we shouldn't be focusing on the cost, it's just an added benefit. We should be focusing on the fact that these people are less likely to reoffend and therefore less likely to engage in this behavior and cause the fatal accidents and serious bodily injury accidents that we're all trying to avoid. Participant benefits, this is another issue, is not only do we have to get the public behind this idea of treatment versus just straight incarceration, but we actually have to get the participants to buy into the program as well. I've had more than a handful of defense attorneys come up and say, can't my guy just spend 6 months in jail, a year in jail, and not have to deal with probation and treatment? He just really, really doesn't want to do that treatment aspect of it. And that to me is mind-blowing. Like, I don't want to spend a day in jail, let alone be willing to spend 6 months in jail. Personally, just me, I'm going to take that probation sentence 100 times out of 100. But these people are so addicted and have been addicted for so long that a lot of them would rather just serve jail time than actually address the issue and begin treatment. So how do we incentivize them to actually participate in a program like this? Well, what we're doing from the state's attorney side is we're making two what are rather disparate offers. You can either go through door one, which is the typical non-DUI court sentence, and it might look something like 3 to 5 years to serve in prison. No one wants to spend 3 to 5 years in prison. The alternative is you can go to our DUI treatment docket, get something like 1 to 4 years, all suspended, maybe spend 30 days in jail. We're allowed to sentence someone up to 90 days in jail prior to beginning the program. And that's how it becomes incentivized to join the program. And while it's true that probably a lot of these participants are participating in the program solely to avoid that jail time, once they're in it, they still reap the same benefits as those who might be in it to break the addiction from the get-go. And then, of course, not only are we protecting the public, but we're actually improving the lives of the individual citizen. They're getting clean, ideally. Program participants will be clean and employed. We work with them on getting employment. getting health insurance, things of that nature, so that they become a productive member of society. Now I'm going to pass it over to Mark Young, who's going to describe some of the more clinical aspects of the program, and thank you.
All right. I'm going to stay put if I can, but let me tell you a little bit about some of the clinical criteria that goes into participation in this program. You've heard a little bit about offense criteria. What we're looking to do is serve a very specific population, and that is those who are truly alcohol dependent. They are physiologically and psychologically addicted. Or by the standard of our new DSM-5, we're looking to serve the people that are on the severe end of the alcohol dependence continuum. That is the population that this whole program was designed to support, and it really is in our best efforts to uphold best practice standards to serve just this population, as opposed to somebody that's just abusing alcohol or using. So we use evidence-based screening tools, assessment tools that really help us to make sure that we're serving the right person and considering the right person for this program. No doubt we've talked about the risk and need assessment throughout the day. We also use the need and risk assessment. I believe it's probably the same one that the RIC program is using. It's becoming quite popular. We use the ORAS. And again, we're looking to make sure that we are helping those who are at high risk of reoffending or failing in a lower level of rehabilitation. And we certainly want to help those who are in high need of getting help to interrupt their addiction. So you know what, I forgot to put the clicker here. Oop, I'm going backwards. All right, one more. Okay, real briefly, so I won't bore you with clinical talk, let me tell you a little bit about the overall stages of this program. And when we say stage-based treatment, we're talking about the treatment of this program overall, not specifically just going to drug and alcohol treatment. In the initial stage, we are really looking to make contact with the participant and to help them to stabilize. There's going to be a continuum of acuity for people coming into our program. Some just will not be able to stop and will need medical assistance with detoxing. So we will make appropriate referrals to get them into a detox bed or into a residential facility to get them stabilized so they can return then and begin to work with us. The initial phase is really about them showing up for their appointments, them engaging with us, engaging with the DUI docket team, and especially the treatment provider who's going to be working with them for a substantial amount of time. The initial stage is also a time to help the participant begin to build readiness to change. So as we move into the intensive treatment phase, this is pretty much a good portion of the body of the whole program. And in this portion, the person is going to treatment several times a week. They're meeting, as you heard Glenn say, with the case manager. They are attending to a spectrum of needs that could be medical, employment, and they're working with the case manager to solve any barriers that are getting in the way of them getting help. This is a time for participants to learn and practice new behaviors that support their sobriety. This is a time for them to learn relapse prevention skills and relapse recovery skills should they slip or fall on their face and need to be picked back up and get retracked. This is a time of helping the participant to improve their psychological functioning, their cognitive functioning as they're getting sober, and getting oriented to this larger challenge ahead of them. This is a time of helping people to connect with a clinician to do some family work. This is a time for them to begin to build a healthy social support network that includes people in their lives that aren't using, that are clean, and take that as a serious commitment. We highly emphasize participation in the sober support networks such as AA and NA, and that is an expectation of participation in this program. Moving into the maintenance stage of the DUI treatment docket, the focus becomes more a matter of ongoing relapse prevention, individual counseling if needed, absolute active participation in, again, in the community-based sober support networks. It's a tongue twister. And this is a time where the participants who are coming down the latter portion of this program can begin to mentor the newer participants that are just coming into the program that may never have been clean in their adult life, or it may not have experienced sober time in a very long time. And so we're going to look to their expertise and experience to help our new folks coming in. You know, without going much deeper into what's going to happen from a treatment perspective, I do want to acknowledge that this program is really designed to help people make significant life changes. We're going to spend at least 18 months with the participants who are ready to do the work. And we want to give them everything that we possibly can so they can have a lifetime of sobriety. We're not looking for them just to hold their breath, show us what they want to show us, and then resume old behaviors. We're going to work really hard over the 18 months to curb, like you heard Stephanie say, we're going to curb all the maladaptive behaviors that we can and incentivize everything that's working. And this program does work. And I'm really excited that we finally have gone live, and I look forward to coming back and telling you about how it's going in a year. So, thank you.
I think the idea was that the last couple minutes of our presentation could be for question and answers if you guys have any questions.
Why do you wait till the third time person EW3s or EW2s when the first one you use to tag off?
So we're trying to isolate the high-risk, high-need population. I think Stephanie touched on the statistics that suggest that these are the that is the population that is most likely to be the cause of a fatal accident on the roads. And so the vast majority, as I'm sure many of you are aware of, or maybe not the vast majority, but the majority of DUI 1s never get a DUI 2. The one time is enough to kind of scare them straight, so to speak. So we're trying to isolate that high-risk, high-need group who, you know, a DUI offense and $750 fine wasn't enough to get them to stop engaging in that behavior. The DUI 2 with 18 months of probation and, you know, 60 hours of community service wasn't enough to get them to curb that behavior. So they've already established that the baseline responses aren't sufficient and therefore are going to need this higher level of treatment.
Well, I was just going to add, I think I have the article with me too, that there is also studies that show that out of that population for the first-time offenders that again, as he said, like, you know, 3/4 don't reoffend, but out of that other group, if they're still part of a lower risk, lower need group and you put them in with the high risk, high need, you can actually do harm to them. They get criminogenic attitudes and ideas that they didn't have before. So, and I have it with me if you want to read it.
Just a quick question. You said that in order to sort of steer people into your court, that you offer two alternatives. One, for example, of a 3 to 5 year sentence, and one that looks like a lot less than that. Are your judges backing you up on that in terms of people who just say, I don't want to deal with you at all, and go plead straight up to the judge? Are they imposing those types of sentences?
I actually haven't had anyone that's taken the more traditional path yet. Anyone that's been offered the DUI court so far has sought to participate in the program. So I can't really respond to that as to whether or not the judge sitting in Windsor County right now, how she would feel about accepting the more traditional sentence. I can tell you that Judge Carroll is a very active participant in our program, and she is the sitting criminal court judge right now. So sorry, but haven't encountered it yet.
I mean, a chicken, you would never get that kind of time on a police straight up. So I was just curious what would happen if people said, well, thanks, but no thanks, I'll just go talk to the judge.
Yeah, I mean, traditionally, at least in Windsor County, something like a 2 to 4, 2 to 5 year sentence on a third offense DUI is not uncommon. I think something that we have to keep in mind is while that sounds like a lot, a lot of these DUI offenders, they qualify for work camp, so they get that discount in time. There's the DUI furlough program. So even though we've sentenced them to 2 to 5 years, a lot of them can get out in less than a year on that same sentence.
Thanks.